Welcome to Tenancy Talk. This vlog contains sensitive subject matter, and viewer discretion is advised. We acknowledge that this case involves real people and real loss, and we offer our respect to all of those affected. The aim of this analysis is to highlight how neighbour disputes share common themes across the globe. This is not a criticism of the Florida police or any agency involved. This vlog does not cover Florida's Stand Your Ground laws, as they involve a separate legal framework. Here I focus specifically on the shared themes of neighbour nuisance and escalation. The content is provided for educational and awareness purposes only. At the center of this story is a mother of four who lived in Ocala, Florida. An ordinary family living their everyday life, using shared outdoor space with full permission from the landowner. But next door lived someone who increasingly behaved as though they had the right to control that land. The conflict focused on children playing in an area the complainant did not own, did not rent, and had no legal claim over. Yet the neighbour made repeated emergency calls, treating harmless children's play as a personal attack. The perpetrator showed a strong sense of entitlement, placing her preferences above her neighbour's rights. She showed no regard for the children, no regard for the mother next door, and no recognition that the land was not hers to control. Her constant call-outs to emergency services were never challenged. No formal warnings were given, no boundaries were set. Meanwhile, the mother receiving the complaints was left unsupported. She was not informed about her rights, not guided on legal protection, and not helped to understand the seriousness of the escalating hostility. What began as a dispute over children playing outdoors escalated into unthinkable violence. The mother of four was tragically killed by the perpetrator, a devastating loss, fueled by entitlement, hostility, and deep-rooted, unchecked bias. Although this tragedy took place in Florida, the themes are deeply familiar within the UK. Neighbour disputes often escalate when unreasonable complaints go unquestioned and when bias determines who is believed. The Housing Ombudsman's Spotlight Report, Time to be Heard, 2022, highlights a critical problem. The report found in its findings a fundamental unfairness. Registered providers of social housing frequently investigate normal everyday noise through the lens of an antisocial behaviour (ASB) policy. The report states clearly, noise is never just noise. This includes sounds such as children playing, footsteps, or ordinary family activities. By treating these as antisocial behaviour, residents can face unnecessary investigations, stress, and long-term harm. The Ombudsman recommends adopting a good neighbourhood strategy, which includes managing noise nuisance proportionately, distinguishing normal life noise from antisocial behaviour, and applying fair evidence-based approaches. In the UK, legal frameworks exist to protect residents, families, and children. Landlord and Tenant Act 1985, landlord's duties including safety, repairs, and reasonable behaviour. Housing Act 1988, possession grounds for antisocial behaviour. Ground 14, nuisance and annoyance. Ground 7A, serious criminal offence. And Ground 12, breach of tenancy conditions. Children Act 1989. The welfare of the child is paramount, recognising their right to safety, play and development. Equality Act 2010. Protects individuals from discrimination based on protected characteristics, including decisions influenced by bias. Protection from Harassment Act 1997. Repeated unwanted behaviour, including persistent unreasonable complaints, can be harassment. Antisocial behaviour, Crime and Policing Act 2014. Tools like community protection notices and injunctions to address genuine ASB proportionately. Crime and Disorder Act 1998 covers racially aggravated offences. The perpetrator in this case had repeatedly used racial slurs towards the children. These laws prevent escalation, protect vulnerable residents, and ensure fair, evidence-based responses to complaints. The golden thread linking the documentary to real UK cases is clear. Bias shapes outcomes. In The Perfect Neighbour, the victim did not fit the stereotypical profile we're conditioned to believe, or authorities more readily empathise with. Meanwhile, the perpetrator fit the profile of a victim society is conditioned to be believed, and was treated with leniency even as her behaviour escalated. Bias often forms unconsciously. People tend to trust those who fit familiar stereotypes or appear vulnerable, while dismissing those who do not match these preconceptions. These assumptions influence which complaints are dealt with, both seriously and sensitively, which voices are amplified, and which are scrutinised and dismissed. When bias shapes who is heard and who is dismissed, the consequences can be devastating. The Housing Ombudsman stresses practical steps for anyone dealing with neighbour disputes. Use facts, not assumptions. Keep accurate records, dates, times, events. Stay proportionate. Is it ASB or normal living? Think about the property type and noise transference. Seek support from agencies when needed. Communicate through proper channels. Aim for constructive outcomes. Only escalate when necessary. These steps help prevent resolvable tenancy issues from turning into major conflict. What sits at the heart of this case isn't just a neighbour dispute or a tragic ending. It's the children. Children who were respectful, polite, and simply trying to play. Children who were repeatedly described as threatening, when in reality they were the ones at risk. They were exposed to racial abuse. They were adultified. Their safety, their emotional well-being, and their lived experience were secondary to the comfort of an adult who was making escalating and unfounded accusations. And the moment a threat or perceived threat was mentioned, even as part of her own complaint, that should have triggered safeguarding responses. At the very least, a proactive welfare check, a social services alert, a multi-agency discussion. But none of those pathways were activated. The focus remained on her claims, not on the vulnerability of the children she was targeting. Across the United States, new models like the Transform 911 blueprint recognize this gap. They aim to send the right help to the right call, not just enforcement, but social workers, mental health clinicians, and crisis responders trained to identify risk, bias, trauma, and vulnerability. And although this model isn't used in Florida, the principle it represents is vital. Early intervention protects families, it protects children. Bias is not always cruel and unkind. It wraps itself up in professionalism, processes, kind words, and smiles. The tragic case of the perfect neighbour was a bitter pill to swallow. A case that reminds us how perception, bias, safeguarding gaps, and missed opportunities can shape people's lives and sometimes end them. This is Tenancy Talk, bringing you real talk, real issues, and tenancy rights. If you found this vlog important or thought-provoking, please like, comment, or subscribe. Your support helps us continue these conversations that really matter. Thank you for watching.